Judy, we said 30 days is when, once it's gazetted, then you can start getting letters of administration and moving forward with the succession process. But say, I have never read the gazetted section of my newspaper. So I missed my spouse's gazetting of this process. And so 6 months down the line, I learned that all our land is actually being distributed by other people. What happens in that case?
Okay, so you can apply to revoke the grant. Okay, so ideally, you ought to keep your eyes open, okay?
Yes.
But the ideal situation does not happen in many cases. Courts have discretion. Although you have come outside of the 30-day period, courts have discretion to open up the case for you to participate, even if it's after 30 days, even if it's after 6 months, you see, so long as you have a reasonable explanation that you put before the court. But the 30 days enables the court to know, as long as there is no objection on the record, we can go to step 2. But they absolutely have the discretion to open up, and they do open up. There are so many applications for revocations of grants pending. It's unbelievable. Yeah, because the case you have described it happens too many times. Yeah. So there is an objection, and the objection is resolved, and the court says, you, the person who applied, together with the objector, or you, the person who applied alone, go ahead and become an administrator. We said that person who becomes an administrator is supposed to establish where and what the estate of the deceased person consists of. And after that period of 6 months or sooner, if the court allows in certain circumstances, or later, many times, then makes an application to court seeking to confirm the grant. Remember, we said the letters of administration you got are initial. They're interim. Okay, I use this interchangeably. Letters of administration or grant of letters of administration. Okay, so I use that kind of interchangeably. But there's a difference between the interim one and the confirmed one. So in initial period, you have the interim one. Then you come to the court and tell the court, I propose as an administrator that the estate should be distributed in the following manner. And the beneficiaries, the other beneficiaries or the beneficiaries have agreed. And these are their consents. Consents are attached there. So the court, in a hearing in court, will ask, so who are the beneficiaries of the estate? And many times it is from the letter from the chief. You see, because the court has no way of knowing this person died, who are his people. But the letter from the chief is therefore very, very important. So the court will look at that document and then ask, so are those people in court, the beneficiaries? Of course, they have been named in the court papers as well, you know, the petition and the applications and the affidavit. And those people will say, we are here actually, virtually or physically. Of course, it's a lot virtually. And the court asks, show your ID so that they confirm that those are the beneficiaries. And then the court will ask them, have you agreed to have the estate distributed in the manner that is proposed by the administrator? And if they say yes, each one of them is actually asked. If they say yes, then the court says the grant will be confirmed in terms of 1, 2, 3. Okay, so for example, land in Moranga goes to, Ken, a house in somewhere else goes to Karo. Okay, now, when that is extracted, extraction means now the court gives you that formal document, that document with the seal and everything. You can then take that to the Ministry of Lands, for example, and that property will be transferred in accordance with that grant. If it's about money in an account, Absa Bank, Standard Chartered, 100,000 to go to Ken, the drone guy, $1 million to go to Karo, then the bank, once that's presented, and once they verify that that's a genuine order of the court, they will deal accordingly. So that is what we now say is a confirmed grant. That is the process. And I need to say that people sometimes get frustrated because you take it to the bank and you want to go home with the money. Or you take it to whatever it is, CDS account or whatever it is. And you hope that you can go home with the money. Not so, because many of those institutions, even the police now, want to go to the court file, and confirm that that order is valid, because you know how many fake orders have been issued out here. But here's the other thing that is important. Even in the case of wills, a will is not enough. Much as it is part of estate planning, you still have to take it through those steps that we have mentioned. Okay? You still have to, so in a will, you name an executor. An executor is like an administrator, the person who will take your will forward. Because look, you've written down your will. Who will take it from paper form to the validation process? So that person is called an executor. So many people name executors in their wills. And that executor, who could be your beneficiary, could be an heir, who could be anybody, then takes that will to court, seeking validation of it. That application of his is also gazetted in the Kenya Gazette. It's also given the 30-day notice. If there's anyone objecting, they need to object. And if there is no objection, the person gets an interim grant of probate. Okay? An interim grant of probate. And then, after 6 months or so, they apply for confirmation. The difference is that you now apply for confirmation of probate or grant in accordance with the contents of the will. You see, in accordance with the contents of the will. So that process goes. There could be an objection by a person who says that I have not been provided for. Remember, we talked about heirs or dependents who have not been reasonably provided for. There could be such a person, who then objects, and then the court has to go into a hearing of that case so that it can determine whether that objector has a valid case. And it could well be that the court could say that they fall within the category of people who should have been provided for by the person who wrote the will. And because they were not provided for, the estate will be adjusted so that they can make provision for them. Eventually, you get a confirmed grant of probate. And the confirmed grant of probate then enables the Ministry of Lands, the bank or whoever to disburse whatever it is that's in their institutions, or to transfer property or register transfers of property in accordance with the will as validated by the court. Yes.
In this 6 months, the administrator is looking at what the estates consists of. Right? Well, there's a 6-month period where he's looking through that. So let's say he misses out on a few pieces of properties, or whether it's a bank account here or a property that's somewhere. What happens in that case?
Very good question. You can rectify the grant and include properties that you didn't know of. And it happens very many times because you're shooting in the dark sometimes, so to speak. And that's why planning is important.
Correct.
So you come across a plot somewhere that the person who died had, but it was not within your knowledge at the time that you applied for letters of administration or to confirm the grant. So you go back to court and ask, can I rectify and now include this property? Along the way, you could find another property. Maybe it's even in the unclaimed assets, list or somewhere of it. Then you come back here. So this is why it is so very important for people to be intentional. Yes. Let us know. Let people, I'm assuming I'll always be here, but let the people who will be here, who will be there, let somebody else know what you have. Yes, exactly.